Hi, and welcome to Hull and Hull TV. I'm Dana O'Brien, and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. Ian and Suzana, let's talk about the latest census and its implications for estate planning. According to the census, seniors are the fastest growing age group, and as Canada's population ages, the number of cases of Alzheimer's disease is expected to more than double over the next decade. Ian, as mental health becomes a greater issue, how does that factor into estate planning?
Well, I think the primary thing that I try to keep my clients focused on is the old adage, vote early and vote often. Get in, get your estate plan done, and don't leave it to 5 to midnight estate planning. If we do anything in our life, 5 to midnight, rushing out to the car to drive your kids to hockey, and you end up speeding because you're late, we always think to ourselves, what are we doing? Why can't I slow my life down and not be so crazy with my timing? Well, estate planning is no different. And the onset of dementia and Alzheimer's is a real and relevant factor for so many people. You don't know when it's going to hit, you don't know how fast it's going to hit, and it's a progressive disease. So if you're in early and you're in often, and you're checking your will and making sure it accords with what you think you should do at the time of your life when you're capable, cognizant, and not vulnerable, then you've just created the estate plan that you wanted, not what someone else wanted.
Suzana, what do you think?
I think that's really absolutely true. That coupled with, of course, the power of attorney and making sure that to the extent possible you've got that in place. People always think that they're too young to have a power of attorney or that they don't need one yet. But the reality is that you want to make that decision. You want to make it yourself because otherwise you're going to be subject to some judge determining who's going to make decisions on your behalf. And that may not be the same person that you would have otherwise chosen.
The census also shows a shift away from marriage to more common law relationships, with the number of common law couples rising by almost 14%. So as common law becomes more common, Suzana, what should those couples do to protect themselves during estate planning?
I always am surprised by the statistics, and it's always good to be reminded of them. And it's also good to be reminded of the fact that certainly here in Ontario, there is a difference between people who are married and people who are common law, and that difference matters a lot on death. And so to the extent that you can pre-plan and recognize that difference is very important. We always tell our clients to consider things like having proper cohabitation agreements in place to make sure that their wills specifically provide for that common law spouse and that they provide so adequately, and that we have these communications and the discussions with our family members so that they know what's important to them and what was intended in terms of this relationship at the end of the day.
Ian, do you find that people are often surprised that there is such a big difference between common law and marriage when someone passes away?
Absolutely, because I think this is where our society is 2 steps behind, our governments are 2 steps behind our society. We live and breathe common law relationships every day. We know people who are in them. We presume they are married-like in most cases. Yet the legislation and your rights, legal rights, are not matching up, even close. So the surprise is not just, oh, I thought that I would get half or I would be treated like a spouse, a wife, or a husband. That is coupled with the financial reality is that you simply aren't. And the fight is much more extreme and much more intense when you pass away for the surviving spouse, when you're in a common law relationship.
A recent Court of Appeal decision in Kerrigan versus Kerrigan demonstrates a need for common law couples to have a will. It demonstrates how important it is. Tell us something about that case.
Well, it's a fascinating case in some ways because it illustrates the debate that we're talking about now, and that is that the legislatures are 2 steps behind the rest of us. And that's not uncommon, and that's fair. I mean, governments can only stay up on every issue so often and so current. The Kerrigan decision, though, was a case where the Court of Appeal had to look at who's going to get the beneficiary interest in a significant pension. And there's a debate over a spouse, the married spouse, or the spouse in the house. And that's the common law spouse. So a married spouse, the marriage has ended, maybe they do or they do not get divorced, depending on their circumstances, that you're into a new relationship, you've got two solid relationships here at law, and the court decided that in this case, that the court was struggling with who is the spouse in the house. Should she prevail? That's the common law. Or should it be the married spouse because of all the statutory rights that come with the marriage status? So the Court of Appeal struggled with it. I'm not sure the debate is over by any means, but it illustrates that perfect storm that we are in, and that is that common law spouses simply are not being treated equally or fairly in many respects as opposed to a married spouse.
The census also shows how complex Canadian families are becoming. With more than half of first marriages ending in divorce, that's resulted in more blended families. So you may not see two families coming together at a wedding, but as many as four. So, Suzana, how do you estate plan for so many competing interests?
I think in those situations, it underscores the importance of having professional advice, because there may be arrangements that have come out of previous family law arrangements or contracts that have come out of that agreements that have to be brought into the whole mix as part of the estate plan. So you'll need to make sure that that's covered off. You'll also want to consider the tax and the accounting implications of these kinds of arrangements, and having the benefit of more heads than just the one to plan that and create the perfect plan, I think, is really the best way to deal with it. The other thing that we have to recognize is that in so many of these situations, people want to provide for their first children, but not at the expense of their latter spouse or partner at the time that they pass away. And so that allows for some creative strategies and plans to be put into place where people can perhaps gift during their lifetime to their children without having any cost associated to that to the partner at the end of the day. They can create trusts, they can do some creative tax planning that even after death might also benefit those individuals without compromising the rights of the other surviving spouse.
Now, you've mentioned creative a couple of times. Ian, I suspect that as families become more blended and more extended, that does call for more creative strategies in estate planning.
It does. And what I describe with my clients in these blended situations is get your kids mature now and mature them up now. I don't care what age they are, start learning about the fact that you're going to have a balancing act between spouse one, spouse two, family one and family two, and the kids have to start thinking about it. Now, you can't tell a 4-year-old certain things you're going to tell a 40-year-old, but there's a lot of 40-year-olds that are behaving like 4-year-olds because it's the first time they've really tried to think through what's going to happen here. So mature your kids up. That'll help unfold the whole process.
All right, grow up. Ian and Suzana, thank you. And thanks for joining us on Hull TV.